Good day, CrimeTalk aficionados. Guess what? Bryan Kohberger's attorneys say they're not ready and they want a continuance of the trial date. We've got an update for you from the Sean Combs trial. A bad cop or just a resourceful cop? We have this day in legal history, our quote of the day, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is CrimeTalk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps as well. Now, before we get to today's docket, let me remind you to go to crimetalksearch.com. There you can sign up for a background subscription service where you can do as many background searches as your heart desires on anyone in the United States while you have that subscription. Now remember, whether you want to do one search or 5,000 searches, all the same cost. All right. And when you sign up, you can do a search for somebody. The report is literally generated while you wait. It is emailed to you, and you can even ask that updates be sent to you if information changes. How about that? Now, in that report, you're going to find out if somebody, their phone number is associated with them. And maybe you think, well, I just did that search on my boyfriend and he has this phone number. It says that it's active. Is that his burner phone for meeting all the other girls? You find out that they have 10 different email addresses, but you only know of one. Is that because he uses all those for his dating sites that he is signed up for? You're going to find out if he has any criminal history. You're going to find out his social media presence. You're going to find out if that person that you're looking into, are they a sex offender? Do they have to register? Yes, everything you want to know about somebody, ladies and gentlemen. Go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, let's go ahead and open the record for Thursday, May 22nd, 2025. And yes, the big news of the day, late yesterday, the attorneys for Bryan Kohberger filed a motion to continue. 40 pages, ladies and gentlemen, 40 pages of reasons why they need a continuance. Now, at first blush, you think, wow, that's a pretty lengthy argument. It's all the same stuff. It is a bunch of filler stuff. But let me kind of go through this, all right? I'm going to go through. I'm not going to read all 40 pages to you, although maybe I should. I don't know. But in their table of contents, and then we'll break it down. The court has an obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date because defense counsel needs additional time to review discovery and prepare for the complex merits and sentencing phases unique to a death penalty case. What have we been doing for the last 2.5 years? Bryan Kohberger's attorneys. Second, Mr. Kohberger has a myriad of constitutional rights during these proceedings, all of which are dependent on counsel having the time and resources to prepare for a capital trial in accordance with established professional norms. Why did you take on a second death penalty case if this case is all too encompassing of your time? Effective assistance to counsel. We'll talk about that. Entitled to individual sentencing determination, a constitutional right that is uniquely reserved for a defendant facing death penalty. Well, what the hell have you been doing for the last 2.5 years, Miss Taylor? The right to qualified expert assistance on the part of as part of the guarantees of effective assistance to counsel and an individualized sentencing proceeding. So basically what they're saying is they haven't done anything for sentencing proceedings, right? They have a professional and ethical obligation in a capital case to provide effective assistance to counsel, must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, compile all the information. What have you been doing? The judge specifically asked, have you asked for more resources? No. Counsel requires additional time to fulfill the minimum requirements described above. Counsel cannot review all of the relevant discovery and complete the necessary investigation prior to trial. Continuance is necessary to remedy the prejudice of highly inflammatory publicity released just weeks before the current trial date, including the recent Dateline special and a forthcoming book. Reversal is more likely than not in any case resulting in a death sentence, and a continuance is reasonable. Those are the main points, ladies and gentlemen, but let's go through it. All right. This motion is structured into 7 sections, each presenting distinct arguments for why a continuance is absolutely necessary. The overarching premise is that proceeding with the trial in August of this year, just a few months away, will violate Mr. Kohberger's constitutional rights under the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, and the 14th Amendment of the United States Constitution, as well as various sections of the Idaho Constitution due to insufficient preparation, time, and prejudicial publicity. So let's go through it. First, this court has this obligation to uphold Mr. Kohberger's constitutional rights by vacating the trial date. All right, they're saying the court is constitutionally obligated to protect Mr. Kohberger's rights, including his freedom from cruel and unusual punishment, due process, a fair trial, effective counsel, and reliable sentencing determinations. And since this is a death penalty case, it requires a heightened reliability due to the penalty's irreversible nature. And they cite a bunch of case law for that. Anyway, the court must take extraordinary measures to ensure a fair trial and a reliable sentencing, as the death penalty imposes unique burdens. Proceeding prematurely risks an unconstitutional death sentence vulnerable to reversal. And they go on to say there's a bunch of constitutional mandates. The court's duty to enforce the constitutional protections is paramount, especially in capital cases where the stakes are life and death. A rush trial could lead to errors that violate Mr. Kohberger's rights, rendering any conviction unconstitutional. And the qualitative difference of the death penalty necessitates meticulous preparation to avoid an arbitrary outcome driven by whim, passion, prejudice, or mistake. Insufficient time undermines this reliability, they argue. And the motion argues that the premature proceedings increase the likelihood of reversible error, wasting judicial resources and delaying justice. A continuance ensures compliance with these constitutional standards, and by granting a continuance, you will reduce those risks. Now, they go on and say, counsel requires additional time to review discovery, prepare for both the merits and the sentencing phase, which are uniquely complex in capital cases, due to the need for exhaustive investigative and expert involvement. In Mr. Kohberger's case, there's a bunch of issues dependent on the counsel having time and the resources to accomplish them. Essentially, she's saying, I'm going to be ineffective, Judge. And the Sixth Amendment guarantees Mr. Kohberger effective assistance of counsel at both the merits and the penalty phases, and obviously even more so in a capital case. She argues that adequate preparation and time is essential to avoid ineffective assistance grounds. And then they cite the ABA guidelines defines professional norms for capital defenses, requiring thorough investigation. And Mr. Kohberger is entitled to that meaningful opportunity to present a complete defense under the 14th Amendment. Then we get into the sentencing stuff. The Eighth Amendment mandates that individualized sentencing, considering all mitigating aspects of the defendant's character and the particular offense, be considered. This requires an extensive life history investigation, which is time intensive, she lets the court know. And since this is a capital case, defendants are entitled to expert assistance to support a complete defense and individualized sentencing. Now, experts require comprehensive life history data, which is not yet fully collected. What have they been doing for 2.5 years? For God's sakes, it's not like this guy was roaming around the countryside interacting with people. He grew up with his parents. He went to grade school, junior high, high school, college, grad school. It's not like he had a bunch of friends. Like, who do you need to talk to? Talk to immediate family members. You take a couple of trips. I've done death penalty mitigation. Yes, it is time consuming, but I guarantee you, I asked for a continuance on a death penalty case, and the judge said, nope, we're moving forward. We're moving forward. The job expands to the amount of time given, ladies and gentlemen. Anyway, Ms. Taylor continues in her motion. The Sixth Amendment requires counsel to meet these guidelines, which demand exhaustive investigation and preparation. And without sufficient time, counsel risks providing ineffective assistance, as seen in cases like Wiggins and Rompilla that she cites to, where inadequate investigations led to reversals. And she argues that a rushed trial could limit Mr. Kohberger's ability to present a robust defense, violating his due process rights, and time is needed to explore all evidence, including alternate perpetrators, to counter the prosecution's narrative. She also notes that the Eighth Amendment requires for individualized sentencing, and it hinges on a thorough life history investigation, which, once again, is incomplete. And she notes that a continuance ensures counsel can present adequate mitigation evidence preventing an unconstitutional sentence. And she says she's going to need expert assistance. So by identifying and engaging experts, mental health professionals, it depends on a complete life history investigation. And premature evaluation risks inaccurate diagnosis, undermining both defense and their sentencing strategies. She also gets into her professional and ethical obligations in a capital case. She has a duty to provide effective assistance to counsel, and she must adhere to the ABA guidelines requiring high-quality legal representation and extraordinary efforts in capital cases. And she says that the requirements that she needs to meet must be rigorously investigating all evidence, challenging prosecution witnesses, and preserving all potential legal errors for appeal. This includes exploring alternate perpetrators and subjecting forensic evidence to independent scrutiny. Once again, this life history investigation, the constitutionally adequate sentence investigation, requires this life history, which includes medical records, educational records, interviewing across 3 generations. And this is from the ABA guidelines. And this identifies mitigating factors such as trauma, mental health issues, poverty, and requires contextualization. The investigation is cyclical, expanding as new information emerges, and all about aggravating circumstances, right? The alleged aggravating circumstances, multiple victims, increase the need for thorough mitigation case to counter the stereotypes of basically being a mass murderer, accused of being one, I should say. And juries have rejected death sentences in aggravated cases with strong mitigation, is her argument. So you got to let me do that. Anyway, she says that it requires complete investigation. Mental health and other experts are essential, but depend on a complete life history to avoid an inaccurate diagnosis. Premature evaluations have led to reversal. Now, professional standards. The ABA guidelines are a high bar that is set for capital defense cases, requiring time-intensive tasks like exhaustive evidence review and life history investigation. A continuance ensures counsel meets these standards, avoiding ineffective assistance claims. And since they also argue that the prosecutor's case is nothing but circumstantial, but there's vast discovery, some 15,000 pages, 50 terabytes of interviews, demand thorough review and investigation, including alternate perpetrators theories, which cannot be completed by August of 2025. And once again, going back to the life history investigation, critical for mitigation is ongoing, with new records and witnesses interviewing, revealing red flags that require further exploration. And rushing this risks committing critical mitigating factors. In regards to the aggravating circumstances, the sensational nature of the alleged crimes necessitates this robust mitigation narrative to humanize Mr. Kohberger and counter public and juror bias, requiring additional preparation time. And since this case is very expert dependent, they need specialized experts. For example, they think there's a need for specialized experts, for example, like a neuropsychologist for potential conditions like fetal alcohol syndrome. Hinges on a completed investigation. A continuance prevents inaccurate or incomplete expert testimony. And then she says, hey, I just need additional time to fulfill these requirements. Once again, going back to the merits phase of the investigation, she needs time to review the discovery. The defense cannot review the voluminous discovery, 13,000 photographs, 8,000 closed circuit TV clips, or pursue investigation, including alternate perpetrators. The prosecution's resource advantage and failure to identify exculpatory evidence increases the defense's burden. And a cohesive defense narrative is critical in a circumstantial case. I would remind everybody that circumstantial evidence is viewed as the same as direct evidence. There's even a jury instruction that the jury will receive as it relates to that. And once again, they keep going back to this life history. The life history investigation remains incomplete with recent receipts of significant records, barriers to accessing others, and ongoing witness rapport building. Anyway, red flags for mitigating themes require further explanation, detailed in an ex parte supplement. And the rationale for the continuance is basically discovery overload. The prosecution's superior investigatory apparatus has produced an overwhelming volume of discovery, and their failure to flag exculpatory evidence has forced the defense to review everything meticulously. And once again, they keep saying this is a circumstantial case where alternate perpetrators' evidence could create reasonable doubt, but time constraints risk missing such evidence. And they, basically they're saying trials are story battles, and the defense must craft a compelling counter narrative to counter the prosecution's year-long focus on Mr. Kohberger's guilt. And insufficient time in allowing the defense to do this is apparently going to violate Mr. Kohberger's due process rights. The ongoing investigation, they say, with new records, witnesses, is essential to identify all these mitigating factors and experts. And once again, rushing everything violates his Eighth Amendment requirement to an individualized sentencing. And then we have the pretrial publicity. That's right, on the May 9th Dateline special, as well as apparently a book by James Patterson, violates the court's non-dissemination order and prejudices Mr. Kohberger's right to a fair trial. The Dateline special, the defense argues, presents speculative, inadmissible material, for example, motives, reenactments, as credible with expert commentary lacking evidentiary basis. Hence the reason for that. The book that's coming out, which unmatched access to law enforcement exacerbates bias just before the jury selection. And they say, hey, social science shows pretrial publicity increases conviction likelihood mitigated by delay. So basically let everybody take a cool down period and maybe everyone forget about Bryan Kohberger. I don't see that as happening. And then a continuance is necessary to investigate leaks and reduce prejudice. And then, hey, fair trial violation. The 6th and 14th Amendment guarantees an impartial jury, and that Dateline special, the timing just weeks before trial, with its speculative narratives, emotional manipulation, risks juror bias, especially given its exclusive framing, which lends undue credibility for the prosecution. And then, of course, we got the breach, and this may be their best argument. Leaks from law enforcement or the prosecution undermine the case's integrity and witness credibility, requiring investigation. The book that's coming out suggests further violations, amplifying prejudice, and therefore, they say there's research to confirm that the delay in the trial reduces the impact of prejudicial publicity, allowing jurors' impressions to fade and enabling voir dire to better identify impartial jurors. Identifying leaks and assessing misconduct may warrant remedies beyond delay, like sanctions, like what we talked about, like, I don't know, striking the death penalty. But a continuance is the minimum required to address these violations. And basically, hey, judge, if you don't give it, it's probably going to be a reversal because according to their statistics, approximately 68% of death penalty cases are overturned due to errors, often ineffective assistance of counsel for inadequate investigation. And then she goes through a list of many cases where that came true, and the reversals due to failure to conduct thorough life history investigations. She says the Ninth Circuit, which would review this case ultimately, frequently reversed for similar errors. And she gives the judge some cases to read and said that a rush trial increases the likelihood of errors, particularly ineffective assistance of counsel, which is common ground. And a continuance allows counsel to meet these constitutional standards by reducing that risk. Oh, judicial efficiency. Let's talk about that. Reversals, often years later, are costly and delay justice. Ensuring a fair trial now avoids protracted appellate processes. Does it really? Of course it won't. No, it won't. And then the cases that they cite emphasizes that incomplete investigation violates the 6th and 8th Amendment. Additional time ensures that counsel can fulfill these obligations. And the continuance is reasonable and necessary under the circumstances. They say there's no mechanical test that governs continuance, but the court cannot deny them as myopic insistence upon expeditiousness. The defense has worked diligently, filing timely motions and complying with deadlines, but unforeseen challenges, discovery volume, publicity necessitate delay. Constitutional guarantees outweigh modest delays, and public interest favors a fair trial to avoid reversal. And then the defense's diligent efforts demonstrates the request is not for simply delay purposes, but necessity. The complexity of the case, the external factors, the leaks justify additional time, and the right to a fair trial supersedes expeditiousness, especially in capital cases where the error could lead to an irreversible outcome. A fair trial now prevents future reversals, serving justice and for all parties. So there you go, ladies and gentlemen. That's the highlight of the 40 pages. Now, the motion to continue, it articulates a compelling case for delaying the August trial date because it's rooted in constitutional mandates, professional obligations, as well as practical necessities. Each basis upholding constitutional rights, assuring effective assistance to counsel, complete investigations, mitigating publicity, preventing reversal, and the reasonableness of the request is supported by legal precedent, professional guidelines, and some empirical evidence. Now, what does that really mean? Do I think Judge Hippler wants to continue this case? No. Did the defense say what they needed to say to probably get a continuance? Yes. Ineffective assistance of counsel, right? When you get something new, and for whatever reason you're not ready to proceed, you say, Judge, I need a continuance, and by making me go forward, I'm going to be ineffective. Those are the magic buzzwords. Now, the judge could say, no, you've had 2.5 years. You have had all this information. For all intents and purposes, it's not like the prosecution got a head start on you. They received everything about the same time you did, and they've had same amount of time minus, 6 weeks from the time that Mr. Kohberger was arrested, 6 weeks head start. But you've already had a continuance. They set this out thinking that this would be enough time. The defense agreed to it. They alluded to a continuance at the last motions hearing back in April, I believe, or early May. But the judge said, no, don't think so. So is the judge going to be happy with this? No. Is the prosecution going to be happy with this? No. We'll see what the prosecution's response is. I think it will be something along the lines of they've had about as much time as we've had, and we've been able to prepare our case. And frankly, it's harder for us because, we had to go get it all, and we handed it over to the defense. That's something that they may argue. The fact that the defense has met all of the deadlines to date would make one think that they've had sufficient time. Now, it did come out that Ms. Taylor took on another death penalty case in Idaho when she was working on this particular case. Now, I know people that have had multiple death penalty cases, but that's pretty much all they do. And here she has 4 assigned attorneys on this particular case. Ms. Taylor, Ms. Mathis, Ms. Barlow, as well as Mr. Longson, who's, I guess, the first district public defender in that district there. 4 attorneys, right? One's working on trial, one's doing appellate stuff, one's doing motion stuff, and one's doing mitigation. That's kind of usually the way it works. Plus, you got staff, resources, paralegals, investigators doing things. It's not like the attorney is going to do all of that on their own. Does everything need to be reviewed independently by the defense attorney? In a case this size, probably pretty unrealistic that would be the case. You can have somebody else review hours and hours of video and go through and summarize it and say there's nothing on this video of any evidentiary value whatsoever. Okay? So what does it come down to? The judge is not going to be happy. I'm not going to be happy. I was planning my August around the Kohberger matter, even though the trial was going to take August, September. But the reality of it is the judge has to balance this case. The defendant's rights versus the state's rights and the victim's rights to receive justice. but nobody wants to do this case again. Did they throw in all the magic buzzwords? I won't be ready, Judge. I'll be ineffective. I need to do this life history. The judge could say, you know what? Idaho hasn't really put anybody to death in the last 40 years. And if there's error, just add it to the list if we screw up, and we'll do it all again. But we're going to go do this trial in August. That's what I would love to see. It's like he says, no, Ms. Taylor, I think that you are a very competent attorney. You and your team have done great. I'm sure you'll do great in the future. And, over the last 2.5 years, I'm sure you've developed enough to say something at sentencing if it gets that far. Or the judge is going to say, I hate to do this, but I don't want this case to come back. I want to make sure, it's a fair trial for both sides, and therefore he can grant the continuance. If I was a betting man, I like Judge Hippler. He's a no-nonsense guy. He doesn't play games. You would think that he would say denied. But I'm going to lean that this goes 51-49. The continuance is granted. It's going to be close, and he's not going to be happy about it. And I don't think it's going to last forever because, listen, you're listening to a defense attorney of 30 years. If you've got a good case, you want to go try it now. At a certain point, the work has been done. You just, the delay helps the defense. And not in the sense that they're going to probably find some alternate suspect. No. But people on the prosecution side disappear. It's like herding cats. Even when most of your witnesses are police officers, they move to different jurisdictions. They got vacations. They've got family emergencies. And all those things play into whether a case can go forward or all the evidence can be presented. It's delay tactic, ladies and gentlemen. I get they're saying the magic buzzwords, but it's a death penalty case, and they're looking, hey, the longer this goes, the longer nothing bad happens for my client. All right. That's all I got to say about that for today. Next on the docket, an update on the Sean Combs case. That's right, the 9th day for the Sean Diddy Combs federal sex trafficking and racketeering trial featured testimony from rapper Kid Cudi, or Cudi, however you pronounce it. I don't know. Cudi. Former assistant George Kaplan, makeup artist Mila Morales, and hotel manager Frederic Zamor. The prosecution is obviously trying to prove that Combs led a criminal enterprise involving coercion, violence, drug-fueled freak-offs, while Combs denies the charges, with his defense admitting to domestic violence, but contesting the trafficking and racketeering allegations. So the rapper Kid Cudi, whose actual name is Scott Mescudi, Mescudi, dated Cassandra Cassie Ventura briefly in 2011 during a period she claims that she was on a break from their relationships with Mr. Combs. Anyway, so the ex-boyfriend back in 2011 received a panic call from Ms. Ventura. Ventura called him and sounding stressed, nervous, scared, alleging Combs learned of their relationship and demanded his address, the boyfriend's address. Cudi took her to the Sunset Marquis Hotel for safety. Mr. Cudi testified that Combs' assistant, Capricorn Clark, called him, claiming Combs and the associates were at the Hollywood Hills home. And Cudi found open gifts, his dog locked in the bathroom, and Chanel items disturbed, though the front door was unlocked. And then there was an incident of a car arson in January of 2012. Mr. Cudi's Porsche was set ablaze with a Molotov cocktail. He suspected Combs' involvement, showing jury images of the damaged vehicle. No direct evidence linked Combs, and DNA evidence pointed to a female, actually. Anyway, the rapper met Combs at the Soho house, described his calm demeanor as off-putting, and likening him to a Marvel supervillain. Combs denied knowledge of the car fire when he was confronted about it on cross-examination. The defense attorney suggested that Ventura misled Mr. Cudi about their relationships with Combs, to which Cudi agreed both were played by Ventura, who continued freak-offs with Mr. Combs. Now, the question is, does this bolster the prosecution's narrative of Combs' alleged violent retaliation against romantic rivals? Though there's a lack of direct evidence weakens, obviously, the arson claim. Then they heard from George Kaplan, a former personal assistant between the years of 2013 and 2015. Anyway, he worked for Combs and witnessed quite a bit of abuse. Specifically, back in 2015 on a private jet, Kaplan saw Combs standing over Ventura, who was on her back her legs raised after a glass shattered. Ventura screamed, "Isn't anybody seeing this?" Kaplan did not intervene, he said, citing, his career aspirations. There was also the abuse of a woman by the name of Gina Hunn. Back in 2015, Kaplan witnessed Combs throwing apples hard at Miss Hunn, who shielded herself, and Kaplan left and later quit, uncomfortable with Mr. Combs' behavior. Kaplan cleaned hotel rooms up for Mr. Combs after freak-offs disposing of alcohol bottles, baby oil, and drugs to protect Mr. Combs' image. Rooms were booked under aliases like Frank Black. He bought MDMA and an unknown substance for Mr. Combs, but he did praise Combs for teaching work ethic and still wished him well, but quit after all of the abuse that he witnessed. Obviously supports the allegations of pattern of violence and the cover-up of the operations, Mr. Combs. Then we heard from Mila Morales, a makeup artist, worked with Miss Ventura, considering her a little sister. At the Beverly Hills Hotel back in 2010, Morales heard Combs angrily enter, demanding Ventura's whereabouts. After hearing yelling and screaming behind a closed bedroom door, Ventura emerged with a swollen eye, busted lip, and a knot on her head. On cross-examination, the defense noted that Morales only heard, not saw, the incident and highlighted her media appearances, suggesting bias. Ms. Morales confirmed receiving $1,000 for some photos. But once again, it does provide some eyewitness corroboration of Ventura's abuse. Allegations, though limited to people just hearing it. Then we heard from Frederick Zamore, the Beverly Hills general manager, where Combs frequently stayed. Combs used aliases like Frank White and Frank Black to for stays linked to freak-offs. And the guest's profile noted excessive oil and candle wax requiring deep cleaning and a $1,000 damage pre-authorization. Staff were instructed to set rooms at 75 degrees, stock fruit and chocolate, and use a lot of air fresheners. Kind of corroborates Ms. Ventura's testimony about the nature and the aliases used for Combs' hotel-based activities. Anyway, Thursday's testimony painted a vivid picture of alleged abuse, coercion, and cover-ups within Combs' orbit. And rapper Cootie's account of burglary and car arson, Kaplan's description of violence and cleanup duties, Morales' recollections of Ventura's injuries, and Zamore's hotel records collectively support the prosecution's case of the criminal enterprise. The defense, however, challenged witnesses' credibility and framed Ventura as manipulative, aiming to distance Combs' admitted domestic violence from the trafficking and racketeering charges. The trial continues to unfold, and we'll see where things go tomorrow and next week. Next, bad cop or just a resourceful cop? That's right. A former California police officer faces charges in an alleged $600,000 disability fraud scheme. That's right. A former Westminster Police Department officer by the name of Nicole Brown is facing serious legal consequences after allegedly defrauding the state of California from $600,000 in disability payments. Now, according to the Orange County District Attorney's Office, Brown claimed a minor head abrasion sustained during an arrest in 2022 that it caused a severe post-concussion syndrome, rendering her unable to work. However, prosecutors allege she lived an active and robust lifestyle while collecting tax-free disability payments, leading to 15 felony charges that could result in up to 22 years in prison. So, while claiming to suffer from debilitating symptoms, Brown is accused of engaging in activities inconsistent with her reported condition. Prosecutors state she attended the Stagecoach Music Festival, where she was seen drinking and partying. Just 3 days later, during a Zoom meeting with the Westminster Police Department officials, Ms. Brown appeared in a darkened room, asserting she could not tolerate looking at the screen due to her condition. Her active lifestyle reportedly extended to multiple ski trips to Big Bear and Mammoth Mountain, a vacation to Disneyland, running 2 5K races, attending a youth soccer conference, and frequently attending baseball games. Additionally, Brown pursued an on-loan master's degree in organizational leadership at a local university, further casting doubt on her disability claims. Now, Brown's disability payments totaled $600,000, covering her full salary and medical expenses, all tax-free. These funds were collected over several years while she allegedly misrepresented her health status. Now, also involved, that's right, Miss Brown's stepfather, Peter Gregory Schumann. He's an attorney specializing in worker compensation, is accused of orchestrating the scheme, and prosecutors allege that Schumann acted as Brown's spokesperson in meetings with police officials and facilitated her admission to an inpatient treatment center for traumatic brain injuries. Schumann faces 2 felony charges related to the fraud, which carry a maximum sentence of 8 years in prison. If convicted, he could also lose his license to practice law. Obviously, a significant fraud if Miss Brown is ultimately convicted. And it doesn't look good, obviously, that she's a former police officer or still pending a police officer. Anyway, if Brown's actions are being true, obviously this is a big betrayal of public trust, particularly given her role as a sworn police officer with a duty to uphold the law. The involvement of the stepdad, Mr. Schumann, a legal professional, further complicates the case, raising questions about ethical conduct in the legal and worker compensation area. Yeah, don't get me wrong. I know people truly do get hurt, but there's a lot of fraud that takes place in that stuff, ladies and gentlemen. Anyway, they're going to both face trial with their respective charges, and we'll see how they go. Obviously, they're entitled to the presumption of innocence for both cases. What can you do? Some people's kids, I guess. Next, this day in legal history, May 22nd, 1872. President Ulysses S. Grant signed the General Amnesty Act, allowing all but 500 Southern male voters denied voting rights as punishment for rebellion under the 13th Amendment to regain their right to vote and hold office. General amnesty was finally made universal on June 6, 1898. On this date of May 22nd, 1914, federal prosecutors were pursuing high-profile Mann Act cases targeting interstate prostitution and human trafficking. These cases expanded federal jurisdiction over moral crimes. And on May 22nd, 1930, federal agents conducted raids on illegal speakeasies in New York City, targeting organized crime. And these efforts exposed police corruption and supported prohibition repeal efforts. On this date in 1942, early legal challenges to Japanese-American internment under the Executive Order 9066 were being prepared. Cases like Hirabashi versus United States later tested constitutional limits. Obviously, that was upheld. Later, it turned out, well, we felt pretty bad about that. Gave them a lot of money. Then on this date, May 22nd, 1974, the House Judiciary Committee was intensifying its Watergate impeachment inquiry, focusing on Mr. Nixon, President Nixon's obstruction of justice. This led to the landmark legal ruling on executive privilege. Next on the docket, our legal quote of the day. Justice is the constant and perpetual will allot to every man his due. This is a quote by Ulpian, a Roman jurist. Anyway, the quote somewhat encapsulates the principles that justice involves consistency and fairness and ensuring that individuals receive what they are rightfully owed. A foundational concept, obviously, in legal philosophy, right? Give them a fair trial, then convict them, and then punish them. That's over simplification, but that's generally the legal process. Give them due process, punish them, give them what they deserve. That's justice in most legal systems. And next, our dumb criminal of the day. A serial streaker. That's right. Seattle's masturbator was caught in the act. In a tale as old as time, or at least as old as Seattle police blotter, 46-year-old Keenan Pearson, a registered sex offender with a panache for public performance, has once again found himself in handcuffs. This time, the self-proclaimed masturbator was nabbed for indecent exposure in a Seattle grocery store, turning an ordinary shopping trip into an unsolicited X-rated spectacle. Now, prosecutors who dubbed Pearson a prolific public masturbator alleged he was caught mid-act earlier this month, brazenly exposing himself to a horrified audience, well, that included children. Witnesses reported that Pearson's one-man show was less Cirque du Soleil and more crime scene investigation. When police arrived, Pearson didn't bother denying the charges. "I was stroking," he allegedly confessed, with the nonchalance of someone admitting to grabbing the wrong cereal. Adding a creepy cherry on top, he reportedly oogled female passersby, musing that they'd be perfect for his show and could stroke to it. Charming guy. Anyway, Mr. Pearson's rap sheet reads like a criminal anthology: assault, voyeurism, burglary, domestic violence, possession of a deadly weapon, and the greatest hits collection of indecent exposure convictions. His status on Washington's sex offender registry is non-compliant. Naturally, because why follow the rules when you're busy curating your own grocery store burlesque? Locked up in the county jail on a $150,000 bond he is unlikely to meet. Mr. Pearson is set for an arraignment today. One can only hope that the courtroom offers less of a stage than the produce aisle. Seattle shoppers might want to stick to the online groceries delivery until the masturbator finds a new hobby. And finally, ladies and gentlemen, there's been lots of talk of alternate suspect matters in the Bryan Kohberger matter. I think we found one alternate suspect here that we can all agree on. It's a video. Take it for what it's worth. It's in good humor.
Ladies and gentlemen, this one could not wait, all right? So I'm coming to you live from in front of my entire beautiful town. Look at that son of a bitch, all right? I got to tell you right now, I was doing some research and everybody's saying, oh, you know, the steam tunnels. So that got my curiosity going, you know, the gears are turning. Now, I got on my computer machine and I was looking. We've got a whole, baby, we're talking a whole network of labyrinthine, catacomb-like steam tunnels that run underneath the town. I'm going to throw up a couple images for you, all right? These steam tunnels are big, all right? This ain't no little thing, okay? Now, and what I was thinking is, this November day, it was unusually warm, all right? I think a goddamn land beaver, better known as some parts of Wisconsin, they call him a ditch wolf. Some people call it a groundhog, all right? But I like to call it a land beaver. I think a land beaver went through them tunnels. When they wake up out of hibernation, all right, a ditch wolf, it's got two main purposes: fight other men with its teeth and get some pussy, all right? And now, this bad bitch probably woke up early because it was unseasonably warm that November and went to go fight the only real man in town, Bryan Christopher Kohberger. And surprise, surprise, Bryan Kohberger, he wasn't home, ladies and gentlemen, because he was out driving around like he always does, all right? And now, they probably went to his apartment looking for hell. And guess what? It got some of his DNA on its knife sheath. And it took its knife sheath with it in its little mouth all the way through the steam tunnels back to that Moscow house, loses the knife sheath. And guess what happens? The police find it. Now, ladies and gentlemen, y'all are smart, right? Y'all are reading folk. You go ahead and look up the dictionary. What does it say? Placed. It's the past tense. It's a verb. It means put in a particular place, all right? That means intent, all right? Now, if you read through that PCA, what does it say about the knife sheath? I'll tell you what it says. It says it was placed on the bed, and I know who placed it there. This f***ing land beaver, ladies and gentlemen. North American wildlife, all right? I was looking at that all night. It says in here, all right, a gopher, a woodchuck, can outsmart most people. And if a gopher can outsmart most people, it can outsmart all police officers. Think about it, ladies and gentlemen.
That's all we have for you today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.